Jérémie Jourdan, welcome to Digital Markets Research Hub. There are many experts in the Digital Markets Act and many experts in Digital Services Act who have emerged in the same time and have been positioned as two kind of twin regulatory regimes underpinning, informing, and steering each other. But then eventually, within these 2, 3 years, they have started living their separate autonomous life, and only a handful of us are fluent in both. And I'm very pleased that you are one of those very few creatures capable to communicate and navigate within these two systems. So we have agreed that the main purpose of our conversation will be inviting you to somehow to explain the DSA through the prism of the DMA for people who are in this bubble, and maybe to show the relevance, but maybe we will also look at other issues probably more relevant to the DMA itself. So the focus is on the DSA, implying the DMA, as many connections with the DMA as possible. And with this in mind, let me invite you maybe to provide us a kind of a background, a revision of what has happened over the last 3 years and how this regime matured, how it distanced itself, and why it is still relevant to us.
Thank you, Olesh. And as a starter, thank you very much for inviting me. I'm a huge fan of your podcast, or your YouTube channel, I should say rather, but that I listen while I'm running, while I'm ironing, while I'm cooking. So I've watched or listened most of your episodes. So I'm really honored, and I'm very happy to actually be part of one of those episodes once, and maybe later again in the future. So indeed, I practice both on DSA and DMA issues, and that also dates back to my previous professional life before joining Geradin Partners, where I am now, because I worked for 2 years for a company who was known before as Schibsted, and became Schibsted Marketplace, and became Vend. And I was working there first as a competition lawyer, but also regulatory lawyer, and the second year as a head of public policy as well. And in this life, I looked at the DMA and the DSA, the DMA mostly as a business user, and the DSA more as a regulated entity, because Vend, or Schibsted as it used to be, is a platform in the Nordic countries. So we were regulated under the DSA in Sweden, Denmark, and Finland. So this is where my interest started, and now as a private practitioner, I continue working on those issues. We are indeed a bit more than 2 years into the Digital Services Act implementation, or 2.5 years, but the obligation really started kicking in on the first VLOPs in September 2023. So a bit like we did recently at an event organized by Geradin Partners, looking back at 2 years of the DMA, it's a good moment to look at 2 years of the DSA as well. And there's been a lot going on, to be honest, just similarly to the DMA. There's been a lot going on at the EU level. There's been a lot going on at national level, including in private enforcement. We have seen the first cases going to the European courts as well on challenges against Commission decision. So extremely too-rich first 2 years, I would say. And for those listeners who are not so familiar with the DSA, just a quick reminder that it's a piece of legislation that introduced a two-tier system, where the big guys are regulated, at least for some obligations, in Brussels by the Commission. Those are the very large online platforms, the very large online search engines. And then the smaller guys, like my previous employer, they're regulated in their country of establishment. So you have a two-tier system, very much unlike the GDPR, from which I think the legislator drew some lessons. I think we all know some of the difficulties in the implementation of GDPR, and that's why I think the DSA was designed as a two-tier system. And it's also unlike the DMA, since we're here to draw some parallel, because as you know very well from your activities and research, the DMA is essentially the big guys only regulated in Brussels. The national competition authorities have very little role in the DMA enforcement. Of course, you have private courts and private enforcement. But the DSA is a system where you will see enforcement both at national level and EU level. And when I mean enforcement, I mean firstly administrative enforcement, and then you will also see private enforcement. Now, what happened at a high level in the past 2 years? First of all, we've seen the EU very active. That's, I think, kudos to the Commission for having immediately jumped on this new tool and started first to designate services. And we have 24 designated services as of today. And I will throw out a few statistics at you and at the listeners, but when this video is uploaded, I will upload some slides that also gives the statistics in a more digestible manner. But essentially 24 designated services in various areas. You have marketplaces, pretty much a third of the designation. You have social networks, as you would expect, also a third of the designations. You have, let's put it in a separate category, online platforms that have adult content, which it's about a sixth of the designation. And then you have search engines and a few other types of services, including encyclopedia like Wikipedia, which was designated. Right. So 24 services are now regulated in Brussels and of different kinds. In terms of enforcement, I have counted 18 investigations so far, which is quite a big number, over a 2-year period. We have only 4 decisions adopted to date, and 3 of them are commitment decisions, in fact. So that is quite interesting. And then one of them is a decision for non-compliance and fines. And this is one that hit the headlines last week, as you know, with a fine of 120 million against X for non-compliance with the DSA. There are 14 ongoing investigation. 4 of them have reached the stage of preliminary findings, and 10 of them are still pretty much between opening of proceedings and the preliminary findings. So, and the addressees of these decisions are quite diverse. You have marketplaces like AliExpress, Temu, Shein is not yet proceedings open, but we know they have received requests for information. You have adult sites that are under investigation, and you have the social networks, of course, like Facebook, Instagram, TikTok, which are very much targeted by the first investigations. So that's about enforcement, and we'll discuss some cases, I'm sure, in the next hour. The Commission has also been quite busy with legislative action, like secondary legislation, with delegated acts and some guidelines. So we have, for example, the delegated acts, which regulates data access for researchers. So, people like you who are doing, or those who are doing more work on the DSA, that has been now laid down. There's a delegated act about independent audits as well, and we might touch on that in this conversation. And then some other guidelines, for example, on the protection of minors. I think they're still just in draft, but the final is coming. And some guidelines on transparency reports, and importantly, on mitigating risk, systemic risk for elections. Right? This is a very specific DSA versus DMA angle, but that's the Commission has been quite active working on this secondary legislation. So that's more or less the panorama for the EU. As I mentioned a bit earlier, we've seen litigation in Luxembourg already, and maybe we'll go to that in a minute. But the big picture in Luxembourg is basically the Commission has passed most of the first tests. The designation decision have held up before the General Court. There are appeals before the Court of Justice, so the jury is still out. But the Commission has tripped on one issue, which was the supervisory fee. So we've seen annulment in the Meta and the TikTok case on the determination of the supervisory fee that the Commission levies on the very large online platforms. But litigation has started, and that's only the beginning. Given the number of investigations that I've mentioned, I think we'll see quite a lot of litigation under the DSA. So EU Commission, EU courts, and now national enforcement, the DSCs. So this is maybe where it's starting at a more slower pace. We have published, as you know, an article back in October, which looked at the first annual reports of the DSCs, and the big picture was that things are quite slow getting established at national level. We'll touch on that in a minute, but just earlier this month and late last month, the Irish regulator, the Irish DSA, has actually opened 3 cases against 3 of the very large online platforms, namely X, TikTok, and LinkedIn. So we're now starting to see proper, if I may say, investigations at national level as well. But until now, much of the time has been spent laying down the local regulatory framework and setting up the DSCs, the digital service coordinators, at national level. And then the last building block to finish this panorama is private enforcement. And that I think is very interesting because we're seeing lots of different kinds of cases under the DSA at national level. I hope we'll get to discuss those, but you see from small claims brought by individuals about very small things happening in their interaction with platforms to essentially mass claims brought under the mass claim directives by associations asking for billions in damages. So I anticipate a lot of action in terms of private enforcement and around different kinds of obligation of the DSA.
Amazingly clear and tempting panorama. A few questions for clarification. The first one, can you give us a flavor of the obligations of the DSA? Obviously, there is no need to provide the entire catalog, but just to give how expansive they are, how open textured they are, how difficult they are to comply with. And maybe also, we remember encyclopedic knowledge that it's kind of pyramidal structure, that the higher the platform is, the more obligations are being imposed. But you mentioned that VLOPs are also being investigated by national authorities. So it's not like we have very large search engines and very large online platforms being having given the commission the monopoly to or the exclusive power to investigate, and the rest is for the national competent authorities. The system is slightly more nuanced than this. Can you please explain more?
Correct. And that's one thing that's sometimes confusing because there's this picture that, for the big guys, it's only Brussels that regulates. But the DSA only says that only Section 5 of the DSA, which touches on systemic risks, is for the Commission to deal with. The other obligations, Section 4, Section 3, they are up for grab as well for the national regulators where the platform is established. So as you know, many of those big platforms are actually established in Ireland. This is the issue that we had seen under the GDPR, was a regulator basically having to deal with all the issues linked to the big platforms. But we have a bit of the same under the DSA for the non-systemic risk obligations. And so this is why the Irish authority could start investigating those VLOPs under, for example, Article 20. It's the investigation against X that was open, which is relating to the internal complaint mechanism. So any platform in Europe must have an internal complaint mechanism whereby a user who doesn't like a decision that was taken by the platform, for example, if their account was closed or if their access was restricted for some time, they must be able to appeal those decisions by the platform. And so the Irish authority thought maybe the system on internal complaint system on X is inadequate and could open investigation there. Similarly, the investigation by the Irish authority under TikTok is about those non-exclusive for the Commission obligation. So about notice and action mechanism, about the existence of dark patterns on TikTok, for example, to report illegal content. What the authority in Ireland is investigating is whether the system to report illegal content on TikTok is actually sufficiently user-friendly, if I'm summarizing, right? And those obligations are not related to systemic risks. They're quite clear in the obligation, or those provisions are quite clear in their obligation, and they can easily be applied by national authorities, DSCs, but I think also by national courts. By contrast, and I think this is the logic behind this, is the obligation that only apply on the big guys, on the VLOPs, about the systemic risk, they much more open texture, as you described that. I think your question was a very good one because that's very typical of the DSA. Because if you have very specific obligations, like you need to have a contact point it's as specific as it gets. But then you have this open texture obligations under Section 5, which essentially oblige the big platforms to identify the systemic risks on their platform, number one, and number two, to put in place mitigating measures, appropriate mitigating measures in order to fight those risks. And those risks, they vary from basically consumer protection, classic risks, to disinformation, protection of minors, election integrity. I mean, those are big principles and big risks. And, the manner in which those VLOPs need to comply with that can, take at least 50 shades of gray of colors, right? If not more. So that's extremely open texture. And others are very specific. And, you're familiar with the issue of private versus public enforcement, but the differences in, say, textures between those obligations also has an impact on what you can actually bring to court under private enforcement. Whether some obligations are actually sufficiently specific for individuals to rely on them to sue a platform. And I think that's a debate that we will see in the coming years in private enforcement.
Two more questions. One is narrow, kind of clarificatory, and another is more broader normative. The former one, when a national competent authority investigates a conduct of X or TikTok, you mentioned Ireland being prominent place where they are registered, is it kind of one-stop shop? That does it imply that a relevant authority, let's say in Poland, cannot investigate? So how the precedents take place there? And the broader one is that we have, or maybe let's stop here because I think you already have an answer to kind of quick answer, yeah?
I have an answer, yeah, and the allocation of competence and the cooperation between DSCs and between DSCs and the European Commission is very interesting. So number one, the DSA is quite clear. Is a given platform, if you're not talking about VLOPs in Section 5 on systemic risk, a given platform is regulated by the DSC where that platform is established. So if I'm a platform established in Holland, then my DSC will be the ACM. It will be the Dutch authority. If I am a platform established in Ireland, like Meta, for example, my DSC will be Meta. That means that if a Polish user makes a complaint to the Polish DSC, then that Polish DSC will refer the complaint to the authority in Ireland, right? Which will look into it. And in our report, in our article on the DSC's report for the first year, we've seen actually quite a lot of those referrals between DSCs, and that sort of create a funnel towards Ireland, which will keep them busy, I suspect, on a normal basis. And then you also have the mechanism whereby someone complains to a DSC, a national DSC, but the question is really linked to systemic risks. And that's where the DSC can push the complaint up to Brussels. And we've seen this with, for example, a complaint by Dutch doctors complaining to the ACM about vaping products that were sold on Snapchat. Right. And essentially the open investigation, but now we're seeing the European Commission sending RFIs, requests for information, to Snapchat, meaning that they're probably looking into the issue rather than the ACM.
Okay, and then further clarificatory question on this one. DSC, Digital Services Coordinators.
Correct, yes.
Who are they? What are their mission and competences?
That's another great question that's, I think, not fully settled in all member states. So they're the one who are going to enforce the DSA at national level, right? So every member state must appoint the digital service coordinators whose mission will be to implement the DSA. But what we're seeing at national level is, in fact, several DSCs. So some member states have decided to entrust, full and exclusive competence to one authority to look into DSA matters, but some member states have decided to divide it up between already existing authorities. For example, in France, you have the ARCOM, but also the CNIL, which is the authority for GDPR. And in our article on the subject, we had shown that I think there was about 54% of the member states that had attributed the competence to one authority versus 46% that had actually spread it across several authorities. don't trust those numbers. Go and check our article on this. The actual numbers are there. But the point is, there is actually very different ways of dealing with that issue at national level at the moment.
A broader question to understand the mission, so to say, of the DSA, knowing that the catalog of obligations is quite generous and expansive, depending on which side you are. So we have in the DMA discussions people who reduce the goals of the DMA to the compliance with the catalog of DMA obligations, Article 5, 7, and some others, and a minority which would say that the obligations compliance mechanisms with obligations is primarily an instrument for the commission, where you as a benevolent kind of actor try to select those which fit best to your agenda and your perspective, your strategy, and because it's impossible to comply with all of them even if you are a super heavyweight player, etc. So there are those who say that compliance is a tool rather than the end. And thus, I wanted to ask if something of this kind can be observable within the DSA, is it just the more the better, or we can somehow attribute a perspective where the DSA, at least as far as this very large online platforms and such engines concern, are being tailored, and who are the tailors within the commission? Is it DG Connect or somebody else?
Yeah. So the DG Connect is the orchestrator at the commission, or the actor applying the DSA. So unlike the DMA, it's not split. It's just DG Connect, which I think is probably a good thing. In terms of enforcement, we have seen the enforcement at the commission level touching on several different issues, and some of them are very linked to the news. For example, you may recall that there were questions about manipulation of elections in Romania. I think it was earlier this year. The commission immediately intervened and opened an investigation against TikTok on how those elections were followed, and how transparent was the platform in relation to people intervening and trying to influence this election. So we see enforcement being driven by politics, by the political context. The other recent example is you might have followed the discussions in France around Shein and the sale of pornographic dolls on Shein, which created a big scandal, I should say, in France. The commission reacted, and within a few weeks, the commission sent a request for information to Shein. So we see the commission, of course, being driven as a political institution by what's going on in the news. And then you have, I would say, other obligations that are linked to the setting up of the system. That's also an interesting feature. The DSA is giving a lot of rights to civil society. Take researchers, for example. The DSA is giving researchers the right to access a lot of data in order to be able to analyze what's going on those big platforms. That's Article 40. And the commission has opened a few cases against some of the VLOPs in order to make sure that they put the system in place so that the researchers actually have effective access to this data. For example, the case against X that was concluded last week had a component about that. Not just that, but one. And we've seen also private enforcement cases where the courts have intervened on the basis of this provision. But so I think the commission is both reacting to news, to some to news trends, but also making sure that it enforces the DSA in order to make sure the system functions, right? But the number of provisions, and I think the number of issues that can arise under the DSA is so big that there is a clear question of prioritization at the commission level. I mean, as you know, their resources are limited. And here we see something probably similar to what's happening with the DMA. The commission needs to make choices and prioritize the cases that are the most political, the most important for society, and so on, right? So I think that's also why it's very good to have a system that doesn't just rely on the commission.
And thus this begs the question, we've been in this kind of euphoric condition at the beginning that these are two regimes which are genuinely complementary or expected to be and mutually reinvigorating, so to say. Now we understand that they function as many other EU regimes or any national regime in many respects in parallel. And yet, what are the do we still have some special relationship between the DMA and DSA, given the leading role of DG Connect in both? What is the relationship between them? Do they reinforce each other at least partially? Do they complement each other at least partially?
There's a lot of interesting issues around this one. So one of them is, I mean, of course, some of the actors are regulated both under the DMA and the DSA, right? Big tech, big platforms are, like Meta, for example, is being investigated both under the DSA and the DMA. But fundamentally, those two instruments address different risks and have different purposes. The DSA is very much a question of online safety, and I like the UK denomination of the similar act, which is the Online Safety Act. Right? That's, I think, speaks a lot more than the Digital Services Act. Many of the obligations under the DSA are meant to make sure that we are safe when we are interacting with those online platforms. The DMA, as you know, is much more about contestability and fairness in commercial relationships, right? And of course, there's also a consumer angle in the DMA, but it is very much a competition angle under the DMA. So I think in many ways, the two instruments are indeed parallel. And there's not that many touch points, but they are interacting with each other. And one way in which they are interacting with each other, linked to I think the international context is, if you enforce the DMA or the DSA against big tech today, that has repercussions in America, and we know that the Commission is under a lot of pressure every time they adopt a decision against big tech. So I'm very sure that at the very top level, when you're considering taking decisions against one big tech or another big tech under the DSA, under the DMA, there are arbitrage being made, there are prioritization being given, and the pace of enforcement of the two instruments is indeed interconnected because of that. Now, this may just be a function of the current US administration, which will disappear perhaps in some time, but certainly we see this at the moment. And then there's another interesting phenomenon, but I don't want to play too much because I think it's quite limited. But we have seen in the last couple of months, I think it was in October or November, Apple complaining about contradictions between what they're being asked to do under the DMA and what they're being investigated for under the DSA. In particular, the Commission had sent requests for information to Apple about the systems they're putting in place to ensure safety on the App Store and making sure that kids are safe or that certain types of apps are not showing up. And Apple was very vocal when they responded to the Commission's RFI to say, look, you're asking us to open our ecosystem under the DMA, and we're telling you it creates risks, and now you're asking us, if we're addressing the risk sufficiently. I think they're probably overplaying the contradiction, but we are at least seeing some of them claiming that there is a contradiction.
And this is amazing to ask you, amazing opportunity to ask you as a practicing lawyer with understanding of many elements of this complicated mechanism. Imagine yourself in the shoe of Commission Legal Service team when they were designing these tools. One of the objectives, I imagine, technical objectives, was to minimize this attempts to somehow to use legal circumvention, to use references to privacy, be it GDPR, or security, safety as a shield against enforceability of the DMA. Is there any opportunity at all to design a tool which would have kind of primacy? In Article 8 of the DMA, we have explicit kind of disclaimer that, okay, that it doesn't mean that you are not allowed to, that you are required not to comply with other legislations, which obviously reminds the gatekeepers about this luxurious opportunity they have. They can always somehow amplify one message saying and caricaturize and ridicule the enforcers. And we know how skillful they are in this endeavor. Is there any way to circumvent or to minimize this, or we just have to accept it and in a meditative mode ignore this vibe and go do our job? What's the recipe?
I think I mean the risk is there in the sense that the DMA says clearly that some of the obligations are of course subject to the gatekeeper legitimately introducing some obligations or some features to protect the integrity or privacy of their services, right? Their core platform service. So we have offered them almost, on a platter, an excuse to potentially not comply with some obligations. But it is also correct, right? We do not want the gatekeepers to comply in a way that puts the privacy or the safety of users at risk. So I think the Commission did the right thing by having those exceptions. Expectedly, the gatekeepers are using this to defend some of their actions. The Commission, there's no reason to believe that the Commission is not going to look at that seriously. Also because, as you said, the EU legislator has adopted far-reaching regulation like GDPR or in the area of cybersecurity, other regulations, because those risks are real. So the devil will be in the details. I like your suggestion of turning on the meditative mode. I think there's a lot of noise that will be made, and the Commission should take those concerns seriously, but of course, take them for what they are, bring them back to what they really are. And ultimately, I suspect the court will review the Commission's choices. But I suspect also that the courts will give a lot of discretion to the Commission on many of those issues, because the court will not be very well placed to second guess the Commission here.
Let's move back to the DSA, and we know that there are many different obligations. One are some type of open textured, like this systemic risk assessment, where there is a flexibility, and there are many others. It's probably too early to say which ones are more enforceable or are attracting more attention than others. But if you can give us some flavor about it, maybe rather in the form of forecast or just non-binding reflections and observations rather than just a statement, it would be interesting to learn.
Yeah, I think forecasting is not easy, but if we already look at what's happening, it gives us an illustration. So if you take at the cases that the Commission has already decided, for example, so 4 cases. One was against AliExpress. That was the first one. It was a fairly wide-ranging case that was closed after about 1.5 years of investigation through commitments. And so AliExpress offered commitments. The Commission agreed to them and closed the case. And that touched on so many different issues, including obligations relating to transparency, to the notice and action mechanism, to make sure that there was an appropriate internal complaint handling system on AliExpress. There was also touching on advertising and recommender system transparency on AliExpress, and the traceability of traders, so the famous KYBC, know your business customer obligations. And also, I think, public access to public data for researchers. Extremely wide range of obligations. So that doesn't really tell us which ones will be prioritized, or of course. Then you had the TikTok Lite case, which was very interesting, lasted 3.5 months, very quick enforcement. And there, this was more about the systemic risks. So TikTok announced that they would launch TikTok Lite in France and Spain. And the Commission very quickly opened a case saying, have you done a proper systemic risk analysis in relation to this service, which I think rewarded the users for engagement. And you could clearly see the risk of addiction, especially of the youngest of us, with this kind of system. And TikTok could not substantiate that they had actually done a proper risk analysis, and let alone put in place appropriate mitigating measures. And so within 3.5 months, they committed to pull back the system, right, the new service. And then you have the next TikTok case that was about advertising transparency. As you know, the DSA introduces provisions to make sure that the VLOPs are transparent in terms of the advertising on their platform. And I think there's been a few investigations open there, and the TikTok case is one case that deals with that, where transparency was considered to be insufficient by the Commission. And after about a year and a half of investigation, TikTok now has given commitment in order to improve the transparency of advertising on its platform. So transparency, of advertising is also something that was in the X decision, by the way, that was adopted last Friday. So we see this repeatedly in the open and now closed investigation before the Commission. I also mentioned the access for data for researchers. I think that's a very important provision to make sure that we actually have the research we need around those systems, because I think we are still at an early stage to assess those risks. And the Commission has done cases touching on that. We've seen private enforcement, so essentially researchers association suing, I think it was TikTok. Let me check that. Yeah, I think it was TikTok in German court, or X, and then the court agreeing to actually enforce Article 40, so being specific enough to create rights for individual, and to order injunction to give the researchers access to the data immediately. That was a case in February 2025. Those cases, I suspect, will and hopefully will happen at an early stage now, but in the future, as those systems are being put in place by the VLOPs, I would expect those cases to be fewer and far between, because once the systems are in place and the researchers are satisfied, you should see fewer of those cases. And we have also seen regulatory activity in this space, with the Commission adopting a delegated act concerning regulating access to researchers. Right, so those cases will also probably diminish in the future. So so I think we see a mix of enforcement or action on very specific obligations that are not well implemented, and there's also a private case in the Netherlands against Meta about their recommender system. There was issues both about how easy it was to choose a non-profiled recommender system, and also whether there was at all an option to have a non-profiled recommender system on, for example, for Reels on Facebook. And here the National Court said, I can enforce those, and I think transparency is good on some platforms, and some, for example, for Instagram in some platform, but not good enough on other platforms. And then you don't have the possibility to have non-profiled recommender system for Reels on Facebook. So violation of two different obligations, and an injunction to actually comply with the DSA quickly under threat of fines. Right? Meta said they would appeal, and they've challenged the legitimacy of the Dutch court to do that. But I think the Dutch court did what it should have done. But so you see a mix of very specific court cases, but also enforcement of the more open texture obligation by the Commission.
Can you say a little bit more about the mechanics of this obligation about transparency? Is it somehow related to choice within Article 5.2 and GDPR kind of story, where you can somehow where you offer only two alternatives, and what is at stake with recommender system? How are you expected as the regulatee to meet these requirements? What are on the table?
Yeah, so there's a couple of obligations relating to the recommender system in the DSA, and one obligation is applicable to everyone, and it's essentially a transparency obligation. So the platforms must explain the way if I'm simplifying, but they must explain the way their recommender system function and the options that you can choose. And then the other one is related to VLOPs only, and that's Article 38, I believe, and that's imposes on the VLOPs an obligation to have the two options: a recommender system based on profiling and one that is not based on profiling. Right? So different obligations. One is transparency. The other one is about choice. I think that's different from what you have in 5.2 in the DMA, which is, as you know, about combining data between across platform services, across core platform services or services. But it touches on choices, at least for Article 38, and in that way it resembles, of course, the DMA.
Got it. I also wanted to ask you, Jeremy, about you mentioned several times the mechanism of commitment, and it looks that it's being used effectively, and the very rationale of this kind of dialogical or participative approach supposedly presupposes the mechanism of softer somehow let's meet in between modality where commitment, the mechanism of commitment fits very well. The DMA draft did contain this. Now we see it's being applied almost de facto within this decision by the DMA team to close some investigations within the dialogue. So it's kind of we accepted what has been offered to us. Why do you think we don't have the formal mechanism of commitments within the DMA, leaving aside systematic non-compliance? And is it actually the tool to do things faster and in a less adversarial way?
Yeah, we have a lot of experience with commitment, of course, in antitrust. I think they've proven a very effective way to close cases and to close them with effective solutions. And I think it's as I see it now under the DSA, it's very much the same. The Commission investigates, and some of those obligations are not that clear, and they may be quite open. And so I think the commitment tools under the DSA is a very powerful tool. And especially as we are learning how to comply with some of those risks, it's not so obvious. I was inside a platform for some years, and I know it's not always easy to make sure that you actually have the right system design. And so, especially at this early phase, I think it is a very useful tool to have in order to bring compliance across platforms. But of course, the risk is to overuse it, right? In the sense that platforms may think, okay, let's not change anything, and if we're being caught by the patrol and investigated, then we'll just agree to change it, and then that's it. And then the risk is that you carry over non-compliance for too long. So you have a mix of, as we have seen in antitrust, fines and also commitment, and the Commission must dose or find the right dosage between those two instruments to make sure that deterrence is still there. Why don't we have it in the DMA, sorry? Yes, I think it's much better to close cases with a proper commitment and a decision that crystallizes the commitment, as opposed to have this kind of loose way of closing cases through regulatory dialogues that I think don't leave very much the possibility for those affected to challenge the decision. Right? I think there's less transparency here. That's touching more generally on the lack of transparencies and rights for third parties under the DMA. I was working for a business user for a couple of years, and there's little transparency around things like preliminary findings. So you're very quickly in the dark. And if the Commission enters into sort of dialogue and decide to close investigation, it's not obvious what you can do. So that leaves a bit too much discretion on the Commission. Maybe private enforcement will be the solution. But then, what happens when the Commission decides to close, an investigation, and then someone is not happy, goes to court to have it enforced under private enforcement? How much will the national court, consider the lack of action by the Commission as a blessing, right? That's not obvious.
Continuing with this thinking, half hypothetical, half real. We know that in the mechanism of commitment, at least formally speaking, the first move is for the suspected undertaken. So they have to offer. And we often hear, again, a little bit amplified, a little bit decorated and emotional pleas trying to characterize the enforcer, saying, tell us what to do. We don't know. We are not, you are unhappy with what we proposing. Tell us. And we observe kind of attempt or cautiousness, maybe prudent cautiousness of the Commission to design remedies themselves, maybe in collaboration with business users. You communicate with business users, with powerful large business user cohort. Do you think they know this kind of the potion, the magic potion, which would somehow make remedies effective, even within the framework of commitments?
It's a very complex question, but maybe more under the DMA than under the DSA. But I think if we go back to the DSA, the Commission is also learning, right? It's a new instrument. What is an appropriate, what is the right level of transparency and advertising, or in the traceability of traders, or recommend the system is something where the Commission is still climbing the learning curve, right? So in the design of remedies today, I think there's quite a lot of room. There's margin for error, both direction, right? The Commission perhaps going too far, and or not far enough. I think normally the way, if we look back at antitrust, the way those things have sort of found an equilibrium was having as much participation of the parties affected into the process, right? So if you design commitment, you want to make sure that the affected parties are part of the discussion and can comment on whatever the VLOP or the investigated company is offering, right? So I think that is a potential issue to make sure that we don't over-enforce or under-enforce through commitments. When you look at the DMA, it is a very live question. I mean, it's notorious that, for example, the investigation around Article 6.5 on Google Shopping is not moving very fast. Let me put it this way: that there are difficulties between all the stakeholders to find the right solution where Google would stop the self-preferencing. I don't think Google has incentives to propose something that's effective, and the Commission is caught in the middle. And I think that's something that is that's a very difficult question, because the Commission, I think, is also not feeling very comfortable designing platforms, right? Be it or designing a search page or so on. And so that leaves room for very long processes where no solution is found, which is, I think, very unsatisfactory for those that are affected. Again, I think it might be more common under the DMA today than perhaps under the DSA.
Let us move to the DSA. You have published recently a really impressive blog post in your Geradin Partners platform blog, The Dawn of DSA Enforcement, Lessons from the Digital Services Coordinator's First Annual Reports, together with your co-authors. A really informative, insightful piece. I wanted to invite you maybe to highlight the key observations from this first annual report.
Yeah, and it of course it starts dating back a little, because we published it in October on the basis of the annual reports of the DSCs for 2024. So it was really looking back in the mirror at what happened in that first year from February 2024 to the end of the year of the DSA at national level. I think the big picture was member states weren't ready. We were promised enforcement from day one in February 2024, and I lived through it when I was at Schibsted, and we saw that in many countries there was no DSC that was yet appointed. The national regulatory framework wasn't there, and let alone any enforcement happening. We even had to consult 3 authorities to determine which one was our DSC, right? And then they couldn't figure it out themselves, so they did ask Brussels eventually. We never got an answer, to give you an idea of what that first year was like. And when we looked at the annual report, that was a very interesting exercise, because we wanted to have an overall picture. And so we saw, a lot of things that were not in place. We saw virtually no enforcement on the first year at national level. And we could identify, which tools were seemingly the most operative. Like, for example, the complaint mechanism. Many of the DSCs, I think, very usefully published in the annual reports how many complaints they had received, for example. And that really encouraged this transparency, because that gives a good idea of what's happening. So that was, I think, the tool that was probably the most used. But in terms of enforcement, we didn't see very much. We did see this funnel effect towards Ireland, right, with many of the DSCs, pushing their complaints towards Ireland because it concerned VLOPs that were established there. And then we also saw the fact that the authorities were starting to appoint trusted flaggers. We haven't talked about that, but I think that's a very important piece of the DSA building, in a way, trusted flaggers. And now, if we stop on this for a minute, there are 53 trusted flaggers that have been appointed across Europe and across many of the member states. Not all, but France is leading the pack with 8 trusted flaggers appointed, followed by Italy, Austria, and Germany. And what we see is, and for the listeners who may not be familiar with it, the trusted flaggers, as their name indicate, flaggers that have been vetted by the national DSCs, and they get a particular status because once they've been approved as trusted flaggers in the DSA, when they flag something to a platform, their complaint or whatever they're flagging should be treated as a matter of priority. So it's an extended arm of enforcement for the regulators. Essentially, those guys will be involved in flagging issues and bringing that to the attention first of the platform, but also, of course, of the regulators and then potentially in courts. And so I think that will amplify enforcement very much, at least transparency, because they will sometimes bring issues, of course, to the public, but they will bring issues to the regulators. And we have now 53 of them across Europe. The biggest category is trusted flaggers, and they're classified by areas of expertise, right? So, for example, 17 of them have IP violation as areas of expertise. So looking at, for example, marketplaces, trying to find counterfeits and trademark violation. You have 17 of them, again, dealing with illegal speech, 16 about cyber violence. So their mission is to flag, instances of cyber violences on social media, for example. And you have those 16 again that are specialized in scams and fraud. So, for example, flagging frauds on Facebook, which we know is a widespread phenomenon. So that was an area that we saw already in 2024, quite a lot of action. So the DSCs had started then to appoint those trusted flaggers, but in 2025, it really increased, right? So 50 of them now. So the overall picture for 2024 was things were being put in place, very little enforcement, but the actors in that whole play were starting to use some of the mechanism in the DSA through complaints and trusted flaggers being appointed. It will be I think we will do the same exercise for 2025 to see where we are on year 2. And when I prepared for this video, I also looked at, okay, what's the state of enforcement at the DSC level? Have we seen many more cases open? And other than the 3 Irish cases that I told you about, we actually haven't seen that much happening at DSC level. So the administrative enforcement remains quite slow at the moment in Europe. When you compare to the Commission with 18 cases, there are fewer cases open at the national level across 27 member states, right? I think that's quite telling.
So coming back to this Ireland problem, because it has been so vividly amplified within the GDPR enforcement or lack thereof, I was wondering, so the DSA designers were trying, one of the objectives to somehow to minimize the shortcomings of the single market, so to say, where the country of sitting makes you a kind of one-stop shop. Not much could be said, could be done, yeah. Apart from having this VLOP and very large search engines being delegated, or their systemic risk compliance, or being delegated to the Commission. Otherwise, if you are, let's say, German regulator and you want to enforce the DSA against company which is registered in Ireland, there is not much you can do about it as this digital service coordinator.
Correct. Yeah. So I suspect this will be partly compensated by private action. Of course, private action has a cost that public action doesn't have. But for example, there was a German case concerning the enforcement of Article 40, so access to data for researchers, where the judge in Germany had to decide 2 interesting questions. One is, is this directly applicable? Right? Can the applicant rely on Article 40? And it says yes, it's specific enough. There's a subjective right here. The second question was, do they have to sue in Ireland? Because this was against, I think it was against X or TikTok, but both of them I think are based in Ireland or established in Ireland. And the judge said, yeah, because the harm happens, where the research is being done, and that was Germany, and therefore, this could be done here. So on something that is, quite easily fixable, I think, I think we will see private enforcement happening, and maybe after 2 or 3 cases, but then the platforms will have in place systems across Europe that actually comply with the DSA. So what I think is quite powerful with the DSA is it offers many options. Right? Especially for the big platforms, from going to the Commission, but I think the Commission, may not seize every single and small issues, or going to national regulator, or going to national court. And yes, we're probably going to see some kind of bottleneck in Ireland. That's inevitable. but that may be fixed partly with private actions.
You mentioned at the beginning, Jeremy, about this not multi-billion, but a billion with this nine-digit private enforcement action, giving us a kind of a flavor about the stakes. So maybe you can, obviously, it's hard to systematize even the information about how many cases have been launched in each of the 27 member states. But what's your flavor? Is it an active mechanism? What are the most prominent, most advanced, perhaps, cases which you can mention?
Yeah, the case I mentioned is actually one case, right? It's a class action that was brought by or a collective claim that was brought by the Dutch Foundation for Market Information Research, SOMI is the acronym. And it touches on several aspects of the DSA. That's an interesting case for that as well. It will be a great test case because it touches on both systemic risks, so criticizing the platform for not, particularly TikTok, indeed, for not having put in place the appropriate systemic risk. So very, as we discussed, open texture obligation. It may well be that the judge will simply say, sorry, this is not, you can't invoke that in this litigation. But also on access to data for researchers or violation of the prohibition to have dark patterns in the DSA or protection of minors. So it's a wide-ranging claim that is indeed claiming billions of damages for the group. And that I think will be a very interesting case to see. It's in Germany, and but it was filed by a Dutch association, and it was filed in February 2025. And if you think about the type of risks that the DSA is supposed to cover, I think, and that's why the drafters did include a specific reference to the Collective Claims Directive. Those type of claims will be brought because we're talking about interest of society. Be it around disinformation, protection of minors, that cannot be brought by one person. It concerns all of us or, groups of us, right? So if you think about risk on elections in a given country, you could bring a claim for, all citizens. So I think this type of action will happen. It will be interesting to see how the judges deal with them. But there's something quite encouraging with the DSA is there seems to be a fairly high level of awareness of the civil society in Europe around those risks, around those instruments. And 2025, I think, is showing that many of those associations are actually using the DSA in order to bring those claims. And the Commission will not be able to address all of those problems itself. We will need to have some claims, including mass claims, that are asking for a lot of money in order to police compliance on some of those platforms. And we know some of those platforms are not particularly willing to comply as of today, be it DMA or DSA. And so this will be a deterrent mechanism.
A sociological question of legal sociology. We know when you deal with cases of such caliber, where the stakes are high, where both parties are very well prepared and convincing in trying to highlight the advantages of their position and the strengths of their position. What is the role of the judge of the courts in this from your observations, not necessarily connected to the DSA, but from your experience as practicing lawyers? How many surprises do you see when being engaged yourself or talking with your peers that you would somehow put 70% to one party and then eventually the 30% one, or the more you know, the more predictable the outcomes are, and the roles of the judges are not mechanistic, but not very kind of policy making with capital P?
I think it varies a lot. First of all, we have judges in Luxembourg who are in a way a bit of a different kind as national judges, but at the end they're all people, right? So when you go to a judge, you need to have a good story, you need to tell a good story, and the judges will necessarily be firstly influenced by what the law says, but when it's not clear, they will be influenced by the context and what's happening around them. So, and some of those cases, if we go back to the DSA, if we stick to the DSA, they are quite loaded politically. I mean, if you think about all the noise around DSA enforcement, with the US, the accusation by some US politicians that DSA enforcement is violating the freedom of speech. Those are extremely big and profound sociological or societal topics, right? So certainly the outcome will be influenced by the conviction of each of the judges, and there will be an element of unpredictability. And there's some people that think it is impinging on the freedom of speech, and others who think not at all, in fact. So there will be an element of unpredictability on some of those cases, and especially those that touch on obligations that are not very clear. Right? When it's a clear legal obligation, I think this will be immune from political interference, or in the mind of the judges. But for those cases which are a bit more open texture, then where there's room for interpretation by the judge, then yeah, there will be more unpredictability and maybe more politics.
Amazing. So I wanted to ask you also about your next big things which will preoccupy your professional activities, and maybe also your juristic mind in the following months in 2020, first half of 2026.
Yeah, so I'm actually fortunate enough not to work on a very interesting antitrust case, which almost makes look like the past, because we talked about the DMA, we talked about the DSA, but antitrust enforcement is very much alive, as we saw in the last week, essentially, because yesterday the commissioner announced an investigation against Google on around AI, and there's a good old Article 102 case where my firm's been involved for complainants. But also last week, the Commission also announced another case against Meta, again an antitrust case, Article 102, for shutting down WhatsApp to AI assistants other than the Meta AI. Again, I am representing one of the parties that is harmed by this conduct, and so that will probably occupy the next weeks and months, certainly the first half of 2026. And it's those announcements were very welcome, especially for those people who have said or been a bit anxious about the Commission's lack of enforcement of antitrust rules in the current very loaded geopolitical context. So that is definitely something that will occupy us. The other fun piece of work for our firm, including myself, is we are representing a few business users in the appeals by Apple against DMA decisions. So there's the App Store case, the so-called steering case. And there is the specification case, which is a very interesting DMA case. No fines, but specification of compliance. Apple has appealed those decisions. We will be representing business users, and I will move at the speed of a court case, so it won't be that much work, I suspect, in the next 6 months, but it will still be very interesting to be part of that.
You mentioned really important cases. Maybe one question on not connecting to the facts of the case, because you are involved on the Italian side of Meta and AI assistants. One of at least in commentaries, it has been mentioned about the possibility or the application of interim relief, which for many is being seen as a kind of universal toolbox, allowing to somehow or mitigating the delay problem or delay tactic, which is so powerful to maintain the status quo. Delay ad infinitum. Is it something which is being considered among the community of litigators and more often? Is it something which business users ask, and what is the attitude to this mechanism by the enforcers and judges, of course?
Of course, in the digital world, as you've yourself observed a few times and others, I mean, there's the question of speed that is important, and market tipping is a reality. If you leave practice too long in force, then there's a risk that it crystallizes the market structure, and essentially some actors are excluded from the market. So I think it is a good thing to have regulators that can act fast in the digital sphere. And that's also why we had the DMA in the first place, is to avoid long investigation that needs to establish dominance and market definition. And the meta case is a very interesting one because indeed the Italians are running an interim measures case. And indeed the Commission has made statement last week saying that they were considering interim measures in that case as well. We were obviously very pleased with that. And I think it is also a reflection of what a lot of regulators have been saying in the last year or so, which is we're watching the AI markets develop. We are very attentive to the risks that some actors are actually leveraging their strong position in one market in order to gain unfair advantages in the AI race. And I think that case is one where we're seeing this happening. And it's very reassuring to see the regulators, acting quick. And we'll see, at the end of the day, they may say, well, maybe there's no need for interim measures. I obviously think there is, but it's really good that they're using the tool and considering it. And I think in some of the DMA cases, you would have expected a bit quicker action, perhaps, because we see, harm being continued over a long period. So I think it's a really good news for antitrust enforcement that the Commission does that. And, with the reform of Regulation 1, they may also facilitate a bit more this type of action, because the truth remains that interim measures for the Commission doesn't mean that they can act overnight. It's still a process that takes a few months. We will see whether the Italians. I think the Italians have the tools to act a lot more quickly, for example, in this case. And it will be really interesting to see how those two combine with each other.
At the end, Jeremy, I wanted to ask your opinion and for your amicable advice to students. Their minds are being so preoccupied with so many things in terms of getting internship and doing their modules well, and they don't see, probably many of them don't see the kind of more strategic career path. If you are sitting in the very rapidly evolving field, you are a key player there. You communicate with equally competent lawyers who definitely see the momentum in this area. And obviously, you probably can project the trajectory of the steps which would make just a good lawyer winning among in strong competition with equally good lawyers, young lawyers. So which skills would you expect being more advanced these days than in the past? Which don'ts you should recommend students avoiding, etc. So how would you share your experience with students?
It's a very topical question, and also, my journey, which has been more than 20 years of practice now, will be very different, I think, from the journey of those who are about to start their own now, because the world's changed so much in the last 3 years. But two observations. One is about what we talked about today, which is, this field is fascinating. It's touching on a lot of issues that are at the crossroads of economics, politics, societal risks and issues, and law. And so I think those who are studying this at the moment is a great choice of them, because there will be so much happening in the future. My second observation is about your question, really, and what skills do you need? A friend of mine, Rick, sent me a picture of a book yesterday, which is called, essentially, it's a French book, but it says, don't study. So recommending to people not to get into studies. Now, you're asking me to recommend things to students, and people presumably are studying already, so maybe that's too late. But the point of the book is to basically look at the usefulness of studies in the current context where AI is changing everything. And I don't know if the book is any good. I haven't read it. But certainly it's a reflection that we all having as practitioners. In our firm, we're constantly looking into how we can use AI and how we are developing AI, our own AI tools in this space. And my biggest recommendation to the students will be you need to start mastering that and using it on a daily basis now. Because if I have to choose between two applicants for a stage tomorrow, and one of them has been using AI daily and another has not, I know which one I'll choose, because that's almost the single most important tool today. And some people say AI will make it so that we don't need students anymore, or not students, but associates anymore. I think we will still need associates in a law firm. You will still need to have partners and associates. But what AI can do is turn a junior associate, a very junior and immature associate, into a super associate very quickly. I think it will allow them to go up the learning curve much faster than I did, much faster than the previous generations did. So learn how to use this, because it could turn you into a much better lawyer very quickly. And if you don't use it, you will lose the competitive race that you alluded to. That's for sure.
Jérémie Jourdan, thank you very much indeed for this really detailed and easy to follow, but very competent and nuanced conversation. I'm very grateful.
Thank you for the invitation. This was a lot of fun. I really love your show. So congratulations again.